Well, at least some of you. Whatever the top of Ethan's head to this group, and some of you guys up here. All right, you guys have a bell ringer on the board. So today we're going to be talking about part of courtroom procedure. So we're in that part of the criminal law unit where we're going to talk about what does it look like to take a case to court. So we're going to talk about opening and closing statements, talk about the courtroom procedure. You guys are going to watch some examples of what it would look like to present an opening statement and a closing statement. And then you guys are going to do an activity. But before we begin, I want to know, would you rather be a prosecuting attorney or a defense attorney? But do you guys know the difference? Okay. Do you guys know the difference well enough to answer the question? This actually might be a really hard one. Miss Mangona and I were discussing which one we'd rather be, and we kind of went back and forth. There's pros and cons. So go ahead and take a few minutes to answer that, and I'd love to hear which you guys would choose. Why? Still?
Yeah, I keep, they always say I think it's more, but none of my people know how to do it. I need like a work order for the Chromebook. I don't know how to do
It's never done. I love it. Right. And you can you don't have to stay. But I think like hearing that it probably depends on your stars. Alright, I'm going to give you one more minute. I hear you guys discussing which one you would choose, which is really good, but I'd love to hear your thoughts on which one you would prefer and why. Alright, I'm going to go ahead and ask if you want to share. Make sure you guys are all listening to one another, okay? Alright, I'm going to let Caitlin go. Did you have your hand up? Okay, which one would you rather be?
I thought it was hard to pick because if I was a defense attorney, I would want to help someone who's actually innocent but is being charged with guilty.
Okay.
But I also wouldn't be able to defend someone who is very clearly guilty, like something really bad.
Okay. So you would, in the long run, you would still prefer to be a defense attorney?
Well, I'm a prosecutor because I would have
Yeah, this is a tough question, I think, if you really have convictions one way or the other. Rod.
I mean, it's like asking, would you rather drink or eat? It's like,
Oh.
So, I mean, that's how I saw it.
Okay.
So, I mean, most lawyers will have both licenses, like prosecuting license and defending.
Okay.
But they usually stick to one. Like, rare occasions, they might change. But personally, I would rather be a defense attorney because, like I said, like most of my cousins are, and they're just ready to do, like, prosecuting is harder. But also could be easier because, like, if you're innocent and you're prosecuting, I mean, it's a hard question.
Why would you think being a prosecuting attorney would be harder?
Because I mean, if you're innocent and like you have good evidence, you're gonna lose the case.
Paige, what were you saying?
It's hard to be a prosecuting attorney because you have to prove beyond a reasonable doubt that they're guilty, whereas the defense just has to poke holes in the prosecuting.
Very good, right? It's much harder to be a prosecutor because you have to provide evidence enough or make a case enough that there's reasonable doubt, right? In the court of law in the United States, you are innocent until proven guilty. It is on the prosecution to actually prove the guilt. By show of hands, how many of you would rather be prosecutors? How many of you would rather be defense attorneys? Interesting. All right. Well, over the course of this unit, you guys are gonna have opportunities to kind of play both roles depending on what you would prefer. So, we're gonna talk about opening and closing statements today. It is kind of a lot of information, and you guys are gonna do an activity where you simulate writing opening statements. Instead, I know some of you requested doing a class debate over the death penalty, but there was a small minority that wanted to do that. So, what you guys are going to do for your activities, we're going to act like the death penalty's on trial. And what would it look like to defend the death penalty or to prosecute the death penalty using opening statements? But you guys have to know what an opening statement is supposed to be before. So, we're going to take some notes. So, go ahead and open up however you plan to take notes. Type them, if you write them. Well, I had them up. Does anybody do mock trial in here or has done mock trial before? I know Mrs. Lynch is doing mock trial, but I kind of want you guys to think of courtroom procedure as a sort of theater, right? When you are a lawyer, there is a level of being a lawyer in a courtroom that requires drafting a script, practicing that script, and acting that script out. So when we talk about opening and closing statements, the opening statement is the very first thing that the lawyer will say before the jury and before the judge. So it's a very important part of the jury process or the court process. So opening statement is an attorney's first chance to address the jury. And tomorrow, or maybe at some point today, we'll talk about direct and cross-examination too, to give you guys an idea of what's the best way to draft an opening statement. In order to draft an opening statement, you kind of need evidence to do that, or you have to have an idea of where you think the case is going to go. And it's intended to give the jury a preview of the case. This is not where you present evidence, though. This is an opportunity to basically tell a story. So when a lawyer, a defense attorney, or a prosecutor gives an opening statement, what they're going to do is they're going to describe the parties the best that they can. And that's the defendant or maybe the victim of the crime. You're describing the people. Why would lawyers do this? Why would they talk about people or the people involved in the crime? What do you think they're trying to do? Because they're not presenting evidence yet. Why would they talk about the people involved and frame it that way? We're going to watch an example. You see it right away. Mason. Yeah, you guys. This is kind of the opportunity for lawyers to appeal to the jury's emotions a little bit, right? Like humanize what's happened, right? Because once the court procedure proceeds with evidence and stuff, it can feel cold and calculated at times, right? Because they have to ask questions in a way that doesn't look leading, right? But this is an opportunity for them to kind of appeal to the emotion, right? There are people involved in this. There are victims. And then there are also people who are accused of crimes that you might try to be painting a picture of innocence. So it outlines the nature of the issue and dispute. It presents a concise overview of the facts and evidence. So even though you're not presenting evidence, it's providing a framework or a desire to provide a framework for what the jury is going to hear over the next time period of the case itself. It frames the evidence in a way that is favorable to the counsel's theory of the case, obviously. So if you're a defense attorney, you're trying to present a theory of innocence for the person that's being accused of the crime. And if you're the prosecutor, you're framing it in a way that is trying to provide evidence beyond a reasonable doubt. And then it outlines what the counsel expects to prove, right? So this is an opportunity for the prosecution to prove that the defendant is in fact guilty. So in a sense, they're storytelling during this time. And there's a reason why when you draft an opening statement, lawyers will actually draft it and memorize it. It's like a script, they're acting it out. So a good opening statement is meant to be persuasive, right? This is your opportunity to appeal to emotions, but it should not argue facts of the case yet. This is not an opportunity to present evidence because, and we'll find out later, there's actually a procedure for presenting evidence. So a lawyer is not going to be presenting evidence at this point, and it is going to ask the jury, well, they're trying to avoid asking the jury to make judgments or inferences at this point. Yes?
Is this a stage where defense attorneys sell their clients or they have good grades and stuff like that?
Yeah, so they're trying to, for example, a defense attorney might try to appeal to the fact that the person that's being accused of the crime actually has a good character record or something like that, right? There's too much about this person that's good to have been the person that actually committed the crime, kind of thing. And they're also, while they might not argue too many facts, it's okay. Sometimes they do try to insert enough information inside an opening statement that eventually when they go to provide evidence, they might say that person wasn't there at the time, and then during the case they'll actually provide the evidence to prove that. Opening statements are not compulsory. You can waive your right to an opening statement, and sometimes they do this so that they don't lock themselves into a theory of the case. And because, remember, juries are there listening the entire time. They're trying to make sense of what the lawyers are saying. They're trying to decide what Paige mentioned about proving beyond a reasonable doubt. And so they're the ones ultimately who make the decision. And remember, how do juries make decisions? What's the number? What has to prove someone is guilty beyond a reasonable doubt? There are 12 jurors. How many jurors need to decide that? All 12. It's not a majority, right? It's not even a most majority. It is unanimous. So it is very hard for the prosecution. The burden's on the prosecution to prove this. And opening statements are a very important part of the process. All right. Yes.
So if they tie, does the judge take it to his own hands?
No, they acquit the case. Yeah, even one person could acquit the case. You could have 11 people agree, and then only one person basically is deciding against it, and they still won't get a verdict. All right, we're gonna watch an example of an opening statement. He's going to describe what a good opening statement is, and then he's going to give an example of it. So pay attention because you guys are going to do an activity where you are going to draft opening statements based on the evidence you have for and against the death penalty. So get some bagpipes.
In the next video clip, you're going to be looking at examples of opening statements. As you're watching these presentations, I want you to listen for those things that are mentioned in the Fundamental Trial Advocacy textbook. We're looking to see if they're telling the story. We're looking for the use of present tense verbs, a story that moves from one page to another, that brings us as members of the jury towards the decision that we want the jury to make without ever arguing out loud, without ever saying the evidence means or this is a case about, that places the juror in the moment. Listen carefully to these examples, and then afterwards, we'll talk about the example, what worked well and what didn't work, and how you can use the lessons that are available in the text to do an even better job.
Picture in your mind a young woman. She's about 35 years old. She's a wife, school teacher, and a devoted mother. Her days in the summertime are spent taking care of her two young daughters. She wakes them up in the morning, makes them breakfast, gets them dressed, and sends them outside to play. She cleans up the house, brings them in for lunch, sends them back outside to play. She does their laundry. She takes care of them. She brings them in for dinner, gets them ready for bed. She makes sure that they brush their teeth, taken a bath, said their prayers. She puts them to bed at night. And after all of that, she takes a little bit of time for herself. She unwinds, she bathes, she relaxes for a bit and goes to bed. Secure in the knowledge that she's safe in her home, that her husband will be home, and she's going to get to do it all over again tomorrow. Members of the jury, do you know what it sounds like when the world ends? Brandy Alexander does. She would tell you that it sounds like gunshots waking you from a sound sleep. It's the blaring of police sirens, the house alarms, and it's the sound of her breath bubbling out of her husband's chest as she tries to bring him back. It's the sound of shouted questions and of children crying. Where's Daddy? What happened to Daddy? I want my daddy. Chris Alexander's never coming back. He was ripped away from his family in an act of brutal violence, senseless violence. And now, the state is trying to rip Brandy away from her, what is left of her shattered family as well. And it's being done following an investigation that lasted a grand total of 3 hours, and that looked into a grand total of 1 suspect. Now, as you heard from the prosecution, they have to prove to you, in order to convict Brandy of anything, that she killed Chris, and that she did so beyond all reasonable doubt. This means that there cannot be any alternative, reasonable explanation for anything that happened. There's only one conclusion, and that you have to find that she killed Chris. The evidence in this case is going to show that that's just not possible. Throughout this case, you'll be presented with a little bit of evidence. And I ask that you bear in mind, what does that evidence show? And what doesn't that evidence show? And at the end of this case, I'll come back and I'll talk to you about why those 2 little girls that you see in that front row should have their mother sent home to them. And why the police and the prosecution in this case should be out looking for the real killer. The killer that they didn't bother to investigate the first time around. Sadly, I can't tell you who that is. We don't know. Because the police didn't bother to investigate the neighbor across the street who admits to having the right caliber gun that caused Chris's death in his hand the night of the murder. They didn't investigate the jilted lover who had authored the threatening notes that were found on his body by the police. They didn't investigate anything. Ladies and gentlemen, I'll come back to you when we're all done, as I've said, and we'll talk all this through, and we'll come to the only reasonable conclusion possible. That's that Brandy didn't kill Chris. She's not guilty.
Mr. Irvin takes a very different tact. He humanizes his client, the defendant, and then he begins to posit the reasonable doubt things that were not done, and makes an argument that regardless of the way you address this case, you just can't find his client guilty. I want you to take the information you see displayed in these slides and combine them with the example that you've just watched.
I'm gonna stop here because I provide a checklist for you guys on your activities, so we don't have to go through that. But, let's talk about this. Can anyone tell what kind of attorney he was? Was he he a prosecutor or a defense attorney? He was a defense attorney, right? How did he start off his opening statement? What were some of the things that he mentioned? Go, Rod.
How she was like a nice young lady who takes care of her children, everyday life. She's a school teacher.
Right. She's a school teacher, she's mom, you gave her age, right? Because obviously she's the one who's being accused of killing her husband, right? What else did he do? Mason.
He created like a kind of like doubt in their minds about the effectiveness or like the legitimacy of what the investigation was to kind of make them feel like it might not be very reliable.
Yeah, how did he create doubt in their minds at the beginning?
He talked about how they only investigated her, and he like described other people that it could have been, but they didn't have any kind of investigation happen on them.
Right. He started to poke holes in the actual police work that was being done. And he mentioned like how long the investigation was, right? How long did he say it was? Yeah, so does it sound like he's presenting evidence? He's presenting facts that eventually he will provide evidence for during direct examination and cross-examination and things like that. So when you have an opening statement, you will need to provide some facts eventually, but those facts have to be backed up, right? So you really, when you create an opening statement, you're pretty rock solid in what you believe the evidence can prove. So let's talk about closing statements, and then we'll be done talking. I'll be done talking. So just like an opening statement opens up the courtroom, a closing statement closes it out. That means that all the evidence that the defense and the prosecution have has been talked through. There's nothing new that can be presented. And this is an opportunity for the prosecution and the defense to kind of provide an opportunity to close out and review and summarize the evidence. Are jurors legal experts? No, they're just regular people. My sister was on a jury in DC this summer, and she told me that after all the evidence was heard and they had to deliberate, they actually called the judge back to talk over the process because they too, there's a sense in which they kind of need an education. And the closing arguments is an opportunity for the lawyers to kind of provide that education. So, okay, you just heard
jurors have bias, though.
Right.
That's why I don't like how random people can be jurors.
Yeah, but the idea is kind of more like a democratic process. Like the idea is, of course, jurors have bias. But what they try to do is provide the least amount of bias possible, which is why to prosecute someone you need a unanimous decision, right? I think if you had like a majority or something, that would obviously prove more bias. But the fact that to find someone absolutely guilty, you need all 12 jurors on the same page. So the closing argument reviews and summarizes the evidence and forcefully explains why the verdict should be granted in favor of the arguing party. So this is another opportunity to kind of appeal to the emotions of the defendant or the victim of the crime. So it's common for both parties to waive a closing argument when a trial is only going before a judge. So believe it or not, Aaron, the difference between a jury and a judge is that judges are biased, but there's only one of them. You have a greater chance of getting less bias with a jury than you do with a judge, believe it or not. And so what they sometimes waive closing arguments because they already assume a judge has made a decision before. Like a closing argument's not going to persuade the judge in a different direction. Where you have 12 people in a room, you're appealing to emotions. The guy just did the opening statement. Imagine that his closing statement is something similar. And there's a woman in the room who is a mother. Right, she's a juror and she's a mom, and she's listening to this and going, yes, her daughters do need to be with her. And you know what? They didn't really prove that she murdered her husband. And all of a sudden you're planting those seeds of doubt. The closing argument is there to kind of continue to grow and cultivate those seeds of doubt. Rob?
And they also pointed out the dog.
Yes. Another way to humanize, right? Because in a sense, they're like the defendant or the defense attorney was trying to make the case that they're victims too, right? Of all these circumstances, right? They've already lost one parent, they're going to lose another one, cetera.
And there's also this thing called like the underdog tactic or the method where what they do is like, so for example, like a game, the losing team also wants them to win. So they
Okay.
present them like, oh yeah, this guy's innocent, and we like hope for them to be innocent throughout the entire game.
All right, so closing arguments should include a summary of the evidence, any reasonable inferences that can be drawn from the evidence, right? So not only what does the evidence like factually say, but can you make an inference about that evidence? Like, for example, if you say the crime happened at a particular time and the person was, 20 miles away, can you make an argument that they wouldn't have been able to arrive at that time in a reasonable way to commit the crime? An attack on any holes or weaknesses in the other side's case, a summary of the law for the jury. And this is important because, like we said, juries are not legal experts. So some of them don't understand the law enough to know what to do and how to weigh in. And then a plea to the jury to make a specific action. So you heard the defense attorney say, not guilty, right? This is another opportunity for the lawyers to say, this person is not guilty. It's like constantly saying whatever verdict they hope to get out of the case. But the arguments have to be based on evidence. Counsel cannot use closing arguments as an opportunity to refer to evidence that was not part of the trial. So you ethically, lawyers still have to stay within the bounds of the case itself. They can't, like, all of a sudden come up with new evidence and provide facts that weren't part of the case already. Yes?
Wait, could he say, the attorney, could he say that where like she did not kill him? Like, could he say that?
You mean the defense attorney?
Yeah.
Can say yes. I mean, that's exactly, he's going to say things definitively like that because he's going to try to prove. So when you are an attorney, you're trying to say things with the most amount of conviction that you have. And that's why being a defense attorney or a prosecuting attorney both of those are pretty hard jobs because you're presenting something as fact, and really your job is to prove one or the other. So, all right, let's watch an example of a closing argument. I think it's helpful to see these things in action. This is interesting because this is an actual case. Murder case.
Ladies and gentlemen of the jury, this is a case about choices. This is a case about the choices this defendant made on July 17th and July 18th. This is a case about on July 18th, 2012, the Daniels family life was shattered. Why was it shattered? Because this person right here, the defendant, chose to break in Mr. Daniels' residence. And when this defendant broke into Mr. Daniels' residence, this is the end result. We have proven each and every element of first-degree murder, of felony murder, and of home invasion. And what you will receive as jurors, you will see instructions. And these instructions will be from the court. And I expect the judge to instruct in the following manner. Specifically, to sustain a charge of first-degree murder, the state must prove the following propositions. 1. That the defendant performed the acts which caused the death of Delmar Daniels, and that when he did so, he did the following. He intended to kill or do great bodily harm. He knew his acts would cause the death of Delmar Daniels, and he knew the acts created a strong probability of death or great bodily harm. Specifically, these are the specific counts. You have 4 counts of first-degree murder. So all we have to prove, and which we have, beyond a reasonable doubt, is these propositions. The state does not have to prove motive. We do not have to prove the lie. We have to prove the who and the how. We do not have to prove the why. Why this defendant chose to do those acts? Not required of us. There is no doubt this defendant was walking around the Daniels residence in bloody feet. There is no doubt. And you can see here, again, more foot, feet print in the kitchen. Again, comparing apples to apples, putting in a position where you can clearly see, there is no doubt that this is his feet. You can see he was walking throughout the kitchen after he murdered Mr. Daniels. The DNA does not lie like this defendant. The fingerprints do not lie like that defendant. And the toe prints do not lie like that defendant. He murdered Mr. Daniels. He tries to hide behind, I don't remember. I want to remember. No, ladies and gentlemen, he knows exactly what he did. He also stated numerous times to Victoria Malone, I effed up and I'm going to prison. Again, consciousness, knowing exactly what he did. There is no doubt that this defendant caused the death of Delmar Daniels. This defendant did. There's nobody else.
Why didn't they show the jury?
Why didn't they?
Yeah.
Probably just whoever was shooting. I don't know if
Hey
When
guys,
they-
I'm
sorry.
gonna ask you,
when they film these things, if they have the authority to do that or not. But, so what kind of attorney was that guy? Prosecutor, right? And he was obviously trying in his closing statements. What did he do? Based on what we just talked about with closing statements. Did he recap the evidence? Yeah, he talked about DNA evidence, he talked about, what the guy was quoted as saying, he talked about bloody footprints that were obviously his. He talked about what charges, how many charges were they gonna charge him with? Four counts of felony murder. So he went over the evidence, he went over, kind of the character of the person, and then also what he was hoping, the verdict he believed was the facts of the case. So when your opening statement is an opportunity to present, your closing statement is an opportunity to summarize. All right, do you guys have any questions about that? About opening statements or closing statements? Because you guys are gonna have an opportunity to draft opening statements. So the reason I chose this activity is because for the past 2 days, you guys have been doing research on the death penalty. So you have facts ready to go. This is due at the end of class. A lot of times your classwork is due on a Sunday. This is due at the end of class. So I provided an opening statement checklist, which is very similar to the opening statement checklist that we saw in that video. So when you go to draft your opening statement, you have kind of like a rubric for what should be included in it. But your job is to imagine, and the reason we chose the death penalty is because you guys have research on it, so you might want to go and find your the 3 arguments that you guys drafted for your position. And if you want to choose the opposite position that you did research on, you guys debated it yesterday, and so now you know what the other side, the facts that the other side presented too. So you are welcome to choose either for or against. But I want you to imagine the death penalty is on trial with a jury. After yesterday's debate, you will be taking either the prosecution, which would be they're against the death penalty, or the defense, which is for the death penalty, right? The defense would be defending the death penalty, prosecution would be against it. Write an opening statement below as the prosecution or the defense. Then you will read your opening statement. So this is something you can do in your small group. So I want you to write your individual opening statements, but if it helps to discuss what that opening statement should look like, feel free to do that. Because when you guys are done, I would like for you guys to read your opening statements to one another in your small group. And then one of you will be reviewing one of your peers' opening statements. Did you find that it did exactly what the checklist did? It provide a narrative, a beginning, a middle, and end that gave you an idea of what the facts of the case are. Or if you're more comfortable, you can do a self-review. That's fine too. Okay? Are you guys good to go? Okay. It should be up on Schoology now. And I'll come around and help you guys if you need it. So remember, like, when you did the death penalty, you had to have the best case in your arguments. So like you would be arguing whatever position you're most comfortable arguing. So like you picked one for or against, but you can flip to all right, I'm gonna give you like till 8:35 to draft your opening statements, and then I will check in to see where you guys are at. So you kind of just pick whichever side you're most comfortable drafting for. And like if you were to present that side, how would you present it in an opening statement? Have someone share the death penalty stuff with you. Unless you are well-versed in the death penalty. And you agree, disagree with the death penalty. Whatever. Well, that's fine.
Are there any tickets? Perfect. Sorry, the condensation on my phone. Oh no, I have some.
Like modern culture. Right. No. Yes. No. Not all. Culture. What topic? So all cultures. I think that our culture. I think but like in our culture.
How many of you guys chose against the death penalty to write your opening statement against the death penalty? How many of you chose for the death penalty? All right. I know that the death penalty is not a person, but you could create a hypothetical to attach yourself to whatever argument you have.
It went black, but it looks like the camera's okay. Of course, every time it does this, it requires a password.
Now, here's the other thing. The difference between what's actually happening and what's Yes. I have a question for right now.
No, I would minor in film just.
Does that mean I can now start talking about my argument? Yes.
Okay.
Okay.
And it'd be like, I
That's kind of
would
the
minor
idea.
in
It's like
film
that's kind of
just
how
say
you have
that.
to.
Did I get a minor in film just
That
when
to find out.
you're
Because when I saw the first part where it's
I
like,
know.
I know. It seems a little like, what's the end?
Have you heard of Ball?
Yeah. Yeah. But they're kind of loose.
I haven't watched it. I just know it's like, I just know people are like, what?
Well, even South America, I've not watched it.
I've never watched it.
Yeah.
I don't know what it's about.
Are you gonna use that data? Like, according to them? Yes.
Here, would you? Girl, no, now.
Okay, so where are your arguments? Think about like the beginning, middle, and end. And it might help.
No, I didn't know about it either. No, I decided I'm not.
Bullet pointing.
No, I just negative. Yeah, you
Oh, yeah. So look here. Yeah, that's piggyback. I mean, that's what I basically wrote for my opening statement. Yeah, that's it. I wanna. Yeah, but this is like, this is. It's like, lawyers do not work alone. You know, they have people that help. I'm reminded this is widely.
I mean, no, we need a bomb. We need to bomb the yeah, and then you can watch it.
You go up to before you decide on anything. can literally go, like, you can, I'll have them.
Yeah, but like,
Well, which one is this? So you guys are at like, I totally love that whole I'm kind of off a lot of it, but is there one that's like,
no,
if you had to husband,
I
I mean, synonyms.
almost don't know.
No, I was scared. I was like,
Right there.
I was like,
Like, I don't.
then I failed.
No, I'm worried for like, no, it's just like common sense, like, no, it's not practice.
And then there was a song in sociology, we would be discussing.
I'm not saying it's a huge, like, factor during a big one. 4 years.
I'm excited for that. Me as well. We're taking a quiz that determines our.
I wasn't even a hostile sexism.
And then the other one that I got wrong. Why did I think I had either of them? Hostile sexism is negative findings towards women. And the other way of saying negative finding harbor ideology that matters.
Attention or perfection?
Oh, yeah.
So for the, just the jury, you want weighted or unweighted?
I think it needs to be on.
Okay, that's all. That's good.
I just don't know what says anything stupid. I don't have Aaron. I really don't.
Oh, I forgot.
Aaron, I know. Aaron, we work like
You don't want it, so you're against it. So you might want it.
Oh, we're talking about. Okay.
Start typing this.
I know.
You might wanna.
He just left. There's like four of us in here that go that fast. Okay. Is he able to log into his computer? It looks like he, yeah. Okay, cool. Thank you. If he comes back and he's not able to log in, shoot me a note. Sure.
I say sure. I don't know how to do that.
Sexism.
How's it going? Great. Or
Understanding prejudice.
why didn't you? So, which, so from your date yesterday, which one? Okay, so that might be the easiest one to make an opening statement, except the one you're not. So what you're gonna do is you're gonna draft an opening statement defending the deputy. So you might come up with a story off of that. The death penalty was necessary.
I'm just really bad.
And you might want to go to drafting agreements that you made.
It will eventually, but this is just kind of practice. To see how much help you take on something you spent 2 days working on. Pull it up. I don't know that. I don't like seeing things get close to my eyes, like on my fingers. Oh no, I have no issues. No, I take it out every day. Plus I'm too scared that like all you sleep and then just like no, exactly.
talking about, what am I, oh. Yeah, that's good.
How long should this be? So that was a good question. I have it more like a time deficit. It's okay if it's a tad short, only because.
I'm not done, but like, I just like didn't know, like, we had to write a full page and I needed to like really fluff out my words.
Yeah, go through that checklist and see if like.
Yeah.
Being concise is hard. You don't want to waste people's time. Like when you think about like talking, sometimes you get too fast.
Yeah.
Too much. That's why I. With preposition. So like, if you're using like to whom, from whom. So if who would be the object, if it was the subject. So here.
Okay, what are you like?
What who sounds really well. So someone who. Yeah.
You think you can drop my side? You doing like this.
It's hard because it's the way to figure the decimal. But it's okay to defend. Somebody who disagrees.
In this case, I would.
Yeah.
I mean, like, if I'm making up a case.
For me, it's like you said, if you're against it, you want to like the definition. So is that what you're saying? I would So in this case, I would try the death penalty. What you want to do is create a case where the death penalty was actually worked and was a good one. You know what I mean? Like, there, so I mentioned Dave yesterday, the guy who just got the death penalty for killing people racially motivated. And he was
Oh my god, yeah.
so I believe that the death penalty should be used, and then depending on the type of
This part, like these three, is that something I write down or is it?
No, so like, I mean, we're not going to do that in this case.
Yeah.
But imagine like, you're not going to have. And he even looked a little nervous.
Or you can look at your.
So because part of it is like, you are performing your child. So
No, it's just actually not.
when you read your opening statement, you write your words, try to make it feel as natural as possible, so that you are to like an idea of what you want to do. Because the 5 questions are forefront. How's everyone doing on their opening statement? Good? Do people have at least something? Okay.
I watched
Remember, if you're comfortable, you're gonna be reading your opening statement.
All of it? No. Don't put that thought in my head. No, put it in. School teacher the same day. Teacher was at agree with it, yeah. Yeah.
Make this rest of the
Make it sound more like so there's that.
like that's like yours, showing that they're living your life of knowing
And
that
then yesterday,
in the presence of society.
you bring your food.
Right now, I'm waiting for I feel bad to lose my money, but I for absolutely.
Well, this actually was like,
She's 16.
if I just listen. Oh, yeah.
I'm like, act like it's me.
Oh, it's really hard. Oh, and then I get back to it. Yes.
That's okay.
But that's the thing. It's a made up concept. Girls are a made up concept that society believes people with their why should this society not that hard?
You want it to be performed?
Yeah, I know.
Okay. Part lawyer is theatrical.
Yeah, but I
Kind of like sleep. Well, we talk about the other one.
Oh, yeah, I'm doing really good. Yeah.
Sometimes shows go in the lawyer.
I know. You're lying.
Stuff is not as, but we want it to be
He's had enough of the past. It's been I don't know.
Yeah.
Well, I think. We're
I'm not saying, I don't want to someone else. If that makes sense. Don't worry so much about the length of these as much as how concise you were. Like, were you able to get across what your position was? Did you say facts? Did you humanize? Did you tell a story with a beginning, middle, and end? Doesn't need to be like an essay.
Yeah, like I already had, so I was like,
No, I'm almost done. My brain is ready to go. The only thing you can be doing is copy and
Why?
I wrote it down. It's like a regular
Thank you.
Alright, how about like 5 more minutes to draft, and then we're going to, in your small groups, you guys are going to read your opening statements if you're comfortable, and then choose someone to peer review based on were there actual ideas in the opening statement. Were they clear as they were speaking? What were the other things? Were they persuasive? And then, did they tell a story without an argument?
I'm assuming just like a little extra. Well, yeah, someone else.
Problem is, to get rid of the death penalty at the state level would require like a Supreme Court decision, that they would have to rule it unconstitutional. And they've since ruled that it's not considered cruel unpatently as a remember the constitution rules it wrong. The individual states want to use it. They have, according to the constitution as of now.
Why did we do
Because the death penalty only applies to actual murder. So if it had resulted in Ronald Reagan's death,
I knew that.
yeah, because at that point, I'm sure, I don't know what the verdict would have been, but he would have gone to prison. Probably wouldn't even gone to prison. Yeah, also, we have a system where we try not to discriminate based on who the person is, but just because he's the president, should someone get a
I mean,
I think we, in the United States, we already have a system that some people have practices called the police It was like, it's writing a Alright, how about like 2 more minutes to get your final thoughts down, maybe some revisions if you need them. And then it's an opportunity for you to share your opening statement with your group. Well, actually, that's right. All right. What I'd like for you guys to do, if you notice on your document, you have a rubric where you're going to put the student's name that you are reviewing, and then you're going to score them based on the rubric. So what I'd like for you guys to do is read, if you're feeling brave enough to do it, it's not compulsory, read your opening statement out loud to your table so you can hear the different versions of opening statements for and against the death penalty. If you are uncomfortable reading out loud, that's okay. You can share your computer screen with a partner at the table, or if you just want to do a self-review, that's okay too. You have 3 options. But either way, I would love if you were willing to share your opening statement as though you were a lawyer defending the death penalty or prosecuting the death penalty. All right, on your mark, get set, and go.
No, it's already Oh, we're reading the last one?
I'm okay. I'm fine with it.
So if you don't want, you don't have to.
I don't care. I'm fine with it.
Good morning, ladies and gentlemen. Okay, this case is about whether or not the death penalty should be capital punishment for innocent crime. These are the conspiracy to the death penalty and capital punishment for those specific crimes. The Constitution will tell you that the death penalty should not be abolished or abolished. This idea is simply designed to be absolute. My counsel and I will show you that not abolishing the death penalty is not a deterrent of crime, and I wish for the victims of the death penalty is not part of execution. Constitutional charge show you. But the death penalty does not deter them. It will show you that the death penalty is required to discharge the others in absence of very aware of the it doesn't sound my counsel will show you requiring and how resolution is for those. Furthermore, the death penalty then they find out they're wrong. 4 years or
Mine's not nearly not good or that one. I'll go. Okay. Okay, are you ready? A man was sentenced to the death penalty and was executed. Shortly after the police found more evidence and found that this man was actually an innocent man. Already was executed for murder. This people is one of the death penalty is something that is no longer or exceptional. How is killing someone justifiable? It's not in any sense. Killing someone is there is no benefit to killing. Hello. Hey, come on. Yeah, no problem.
I met it for a second. I'm afraid of yourself on the trial for murder. Whether or not you're
I'm surprised you didn't feel the way. Well, it's easier.
I didn't like,
Oh my god.
Because you were the one that
For 4 months. 4 months. It's actually these past 2 weeks I have been my first 2 weeks in 4 months. And I don't get the getting I get skin. But sometimes I turn it up too late and it hurts.
How would I know that?
But actually, I started for a long time I did shoulder and back at the same time. PT, so I would have a shoulder impact around the shoulder. So now, actually, the only reason I was talking is because I injured shoulder PT. So we can find that. And then we also have to figure out why we have to do shoulder and back starting next week. I don't think one thing
Yeah, so that was a little bit of a like a weird analogy. Alright, take a second and submit your opening statement sheet. If you delivered your opening statement and also wrote your peer or self-review.
How hard is it to get a C?
How?
Exactly. No, not even a C. It's a D. It's a 61. Yeah. I I took it the grade P class. He's not even in third. Yes. C. What class? They're all merit. His is he has a C in English 12. Not honors. Merit. Yes. I told you. No. He only is taking 2 classes too. No, he's in work study. So he takes 2 classes. Okay, look. I think this is for you. Oh, okay. You want to bring that to your sister? No, he's a 61. They brought it to us, and I was like, I don't think that's not his person. I guess so. I did do it. It's not like, I guess. I don't care what this is. Screw you. It really is. Like, what grade is your sister? She's a freshman. School? Teacher? That needs so much. Did she go to Urbana Middle? No, she went to Wisdom okay. I think there's another Cheyenne. There's a redhead Cheyenne. Oh, okay, that might be. I was like, now like the name. It's just gonna be nothing. But it's gonna be nothing. This is Helen Parks. This is I don't know if you know what this is. He refuses to give me his login information. Or did you know? His parents don't know. Actually, is he close friend? Oh, you don't know. She's tired. Like she would sit down. Next time he wants to hang out, I got a new phone for this. Your boyfriend, sorry. Like, you got the wrong one. Tell me those are German. No, it's alright. Doofendorf. I've never been more proud of a Doofendorf. Okay, Caitlin's like in the middle of it. That's not even German. Yeah, so I'm good. Okay, whatever. Yeah, so that's still I should have took my cat. Yeah. Fine. I don't know. You know, it's like what I did. Actually, I got this following. Like they don't have Toronto. And then I listed a whole bunch of people. Toronto. Which he's from, you know where he's from? Yugoslavia. I get nervous about like Slovenia.
Alright, we're at the end. So tomorrow, hang on, before we dismiss, make sure you submit your opening statements. Hang on, guys, real quick. Tomorrow we're gonna do direct and cross examinations in a trial, and you guys are gonna you're actually gonna look at a case where you're gonna do direct and cross examinations as well as opening and closing statements, as though you are lawyers, either the prosecution or the defense. All right. Thank you for your opening statements. It was fun reading them.
It was. Can I show you what one of my favorite defending statements are?
Yeah, where is it?
It's online. I forget the exact